A child spends 22% of their waking time in a year in a day school. Realizing the criticality of the safety and security of every child, the Supreme Court directed the Ministry of Education, MoE, to develop guidelines for school safety and security. With these guidelines, it has been accepted that schools are accountable for a substantial chunk of the child's life and thus have a huge responsibility to make the stay in schools of all children comfortable, joyful, secure and safe. Accountability. The principal, head of school, teacher, in case of any incident during class or under her watch, and local administration supervising the government-aided school, particularly regarding safe infrastructure, mock drills, training, etc., are accountable for ensuring the safety and security of the children in school and responsible for preventing neglect of any aspect of safety and security of children, or any non-adherence to the safety guidelines, such as the NCPCR's Manual for Safety and Security of Children in Schools, or any other safety norms prescribed by the government, recommendations of SMC, PTA. If, in case of an accident in the school transport after or before school hours, it is found that the school, which has actual charge of or control over the child when the child is in school, has willfully neglected the child that has caused the child unnecessary mental or physical suffering, it may be treated as a violation of the Juvenile Justice Act, 2015 and should be referred to the police by the school authority. Negligence. The negligence committed by the school principal, head of school, teaching and non-teaching staff may be broadly categorized as follows: negligence in establishing a secured infrastructure for the students and children with special needs. Negligence to the quality, standard of the food served and potability of water provided to students in school for consumption. Negligence related to security measures adopted by the school authorities for the safety of students. Negligence in providing timely medical aid to the students. Negligence in taking action against a complaint reported by a student. Negligence on corporal punishment, including mental and emotional harassment. Negligence in preventing bullying, discriminatory actions, and substance abuse in the school premises. No regular monitoring and reporting to the appropriate authority, as mentioned, delaying actions in case of crime or disaster. Suppression of facts and not reporting to the appropriate authority. The school authorities, teaching and non-teaching staff are liable to legal actions in the following cases: giving intoxicating liquor, narcotic drugs, or psychotropic substances to a child without the advice of a medical practitioner, imposing corporal punishment to a child. Corporal punishment means the subjecting of a child by any person to physical punishment that involves the deliberate infliction of pain as retribution. Right of Children to Free and Compulsory Education, RTE, Act, 2009, prohibits physical punishment and mental harassment under Section 17(1) and makes it a punishable offense under Section 17(2). Hatching a criminal conspiracy against a student or suppressing the commission of a crime for any reason, intentional omission to give information of offense against a child, trying to cause the disappearance of vital evidence of an offense against a child or produce any false information during an investigation or before the court, failure to report a suspicion of child abuse.